Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from our UPSC Civil Services examination perspective. Now today let us take up the important news which has appeared in the New Delhi edition of the Hindu newspaper dated 10th January 2022. The news to be taken up has been displayed on your screen and timestamps for these have been provided in the description box below. So on this note, let's start our today's discussion from our UPSC prelims and mains perspective. So let's start our discussion with these two articles appearing on page number 6 and page number 7 in the article section. It says some Raj Bhavans are on war path. The governor must be mindful of being a friend and a guide to his government, more so in the opposition ruled states. And on similar lines, this news says that who should be the chancellor of a university? A governor can discharge the allotted functions as a chancellor in a detached manner. Now, both these articles have mentioned about the aspect of detachment of office for the governor of a state. And this aspect of detachment has been stated particularly for opposition ruled states, that is in such states where there is a different government as compared to the central government. Now in both these articles it has highlighted about the role of a governor as an ex officio chancellor of universities as per the State University Acts. So generally the governor, by the virtue of his office, is the ex officio chancellor of the universities of that particular state. However, of late, we have witnessed certain confrontation with the government, especially in the opposition ruled states. Now, this article highlights certain confrontation between the governor and the elected government with respect to the state of Kerala, Maharashtra, Tamil Nadu, West Bengal, and even Rajasthan. So with respect to Maharashtra, this article highlights that the governor refused to provide dates for the election of Speaker of State Legislative Assembly. And because of this, the Maharashtra State Assembly is without a speaker. Further, with respect to the state of Tamil Nadu, the government passed a bill in the legislature to scrap NEET examination as the only mode of examination for appointment of graduates in the medical courses. However, this bill has been reserved by the governor under Article 201, but even after 3 months has not been referred to the President of India. And in the case of Rajasthan, which happened in 2020, it pertained to Article 174 of the Indian Constitution, especially with respect to power of the governor to summon the House. So we are witnessing this confrontation between the governor and the elected government, mostly in opposition ruled states, on most of these accounts. So in this regard, let us understand about Article 163 of the Indian Constitution, which provides for certain discretionary power to the office of governor, the important suggestions of Sarkaria Commission with respect to the political neutrality of the office of governor, and also some of the important Supreme Court judgments pertaining to Article 174 and also Article 163, especially with respect to the aspect of discretionary powers of the governor. Now regarding the state of Maharashtra, as the governor has refused to accept the date of election of the speaker, so in this regard let us understand about Article 178, which provides for election of the Speaker of State Assembly. So Article 178 clearly puts the focus on the entire Legislative Assembly to elect 2 members of the Assembly to be respectively Speaker and Deputy Speaker, and as such no particular role of the governor has been provided under Article 178 of the Indian Constitution. So in this regard, the author has suggested that in case the governor does not provide for a particular date for the election of Speaker of State Legislative Assembly, then in such case, the rules of procedure of the State Assembly can be amended to ensure that election of Speaker and Deputy Speaker takes place as per Article 178 of the Indian Constitution. And in this regard, the governor should not act as an impediment to a constitutional provision, especially with respect to the Speaker and Deputy Speaker of a State Legislative Assembly. Now talking about the state of Kerala, in this regard, the article highlights the fact that the governor has publicly stated that he was under pressure from the Kerala government to reappoint the Vice Chancellor of Kannur University. Now, as per the State University Act, a vice chancellor can be reappointed. However, the governor has publicly stated that he was under pressure to reappoint. So it also means that the governor did not want to reappoint the vice chancellor to the Kannur University. So the question which arises here is that the governor, while appointing a vice chancellor, is he supposed to act in his discretionary manner, or he has to act as per the advice of his council of minister? Now here the Kerala High Court in Gopala Krishnan versus Chancellor University of Kerala has stated or highlighted that the governor of Kerala need to apply his mind independently against the council of ministers. So there is no need to act as per the advice of council of minister while appointing the vice chancellor of a university. And here, while appointing or even reappointing the vice chancellor, the governor is free to evaluate the performance of the vice chancellor and thereby satisfy himself about the merit for such appointments. Now, despite the fact that the governor has reappointed the same person, but still the governor went public to say that he was under pressure from the Kerala government. So this clearly states the friction between the governor and also the elected government of Kerala. Further, with respect to the state of Tamil Nadu, as I have already stated, that the state assembly has already adopted a bill to scrap NEET exam, that is National Eligibility Cum Interest exam, as the sole guiding factor for admission to undergraduate medical courses. Now this bill has been reserved by the governor of Tamil Nadu for President's consideration under Article 201. But the bill has not been forwarded to the President even after 3 months. So again, the governor can be said to be acting against the constitutional proprietary or against constitutional provisions. And because of all these developments, the Chief Minister of Tamil Nadu has announced or stated that he is exploring the option to empower itself, that is, empower the Chief Minister rather than the governor of the state to appoint vice chancellors of universities. And this can be done by amending the State Universities Act respectively. As by amending the State University Act, this will take away the power from the governor. Now this exploring the idea to amend the State Universities Act to make the Chief Minister the Chancellor of State Universities is not a new idea, and even the government of West Bengal is considering the same. That is to make the Chief Minister Chancellors of all state universities. And the Maharashtra government in this regard has even adopted a bill to curtail or limit the powers of the governor in the appointment of vice chancellors in state universities. So here we need to understand two things very clearly about Article 163 and also the use of discretionary powers of the governor, and also what was the role envisaged for the governor to be appointed by the central government. Now, in order to understand the role bestowed to the office of governor, we must understand two things: that the governor functions as the agent of the center and also that he is the head of the state. But the question is, which one he is more? That is, he is more of an agent of the center or he is more of a head of the state. Now to understand this, we need to go through certain historical backdrop, especially with respect to India gaining independence in 1947. Now in those times, when India got its independence, apart from the states, there were also princely states which exerted its freedom from the central government. Now, various role of the governor was envisaged and fiercely debated in the Constituent Assembly. However, in the backdrop of these princely states exerting independence, it was decided that the governor must be an agent of the center along with being the head of the state. And it is because of this he was given certain discretionary power under Article 163 of the Indian Constitution, so that if any state goes against the central government, then such state can be controlled directly by the center through Article 356 of the Indian Constitution. Or in other words, if the constitutional machinery in a state fails, then the governor, without taking the aid and advice of the Council of Ministers, can directly report to the President about such a constitutional failure of machinery in the state. And based on this understanding and also the then consideration of the fact that some of the states or princely states were exerting independence from the central union or central government, it provided certain discretionary power to the office of governor. but the constitution did not limit or did not provide the factors or the grounds on which the governor can act in his discretion explicitly. So Article 163 says that there shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except in so far the governor is by or under this constitution required to exercise his functions or any of them in his discretion. So it is because of Article 163 there are certain discretions which has been given to the office of the governor which he may use while functioning either as the head of the state or as the agent of the center. And with respect to the removal of governors, the Constitution Bench under BP Singhal versus Union of India highlighted about the dual role of the governor as an agent of the center and also as the head of the state. Further, Supreme Court also held that there may be instances of conflict between center and states where the governor has to act neutrally. So the very idea of providing certain discretionary power to the governor was to maintain a strong union so that states did not wither away from the union, and in case of constitutional failure of a machinery under Article 356, the governor could directly report to the President of India. Now, despite this provision of discretionary power, this discretionary power is somewhat limited also. That is, the governor cannot act in his discretion on every matter. And here the case of Shamsher Singh becomes important. So the Supreme Court in Shamsher Singh stated that the governor has no right to refuse to act on the advice of the Council of Ministries. Now, such a position is antithetical to the concept of responsible government unless such discretionary power has been explicitly provided. Now, this idea of discretionary power was further explained with respect to Article 174 of the Indian Constitution. Now, Article 174 of the Indian Constitution states about the sessions of the state legislature, prorogation and dissolution. Now, it says that the governor shall from time to time summon the house or each house of the legislature of the state to meet at such time and such place as the governor thinks fit. But 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. And Article 174 Clause 2 says that the governor may from time to time prorogue the house or either house and dissolve the legislative assembly. So it talks about both summoning of the house and also proroguing and dissolving the legislative assembly. So as you can understand, the whole issue of discretionary power or acting on the advice of Council of Ministers has arisen number of times in the past as well. So in the Nebam Felix judgment, the Supreme Court decided that the governor can summon, prorogue and dissolve the house only on the aid and advice of the Council of Ministers with the chief minister as the head and not at his own. That is, not in his own discretion. And the court also gave its decision based on the discussion in Constituent Assembly debates, whereby it was finalized not to give discretionary power to the governor under Article 174 of the Indian Constitution with respect to summoning, proroguing and dissolving the House of State Assembly. Now, similar discrepancy happened in Rajasthan in July 2020. Now, the Chief Minister wanted to convene the State Assembly of Rajasthan, however, the governor refused. So, the whole question which arose was whether the governor has discretionary power to summon the House as per Article 174 of the Indian Constitution. And in this regard, the Nebam Felix judgment of the Supreme Court has clearly stated that it is not in his discretionary power of the governor to either summon, prorogue or dissolve the House. And in this regard, the Supreme Court also discussed about the debates which took place in the Constituent Assembly to understand whether discretionary power was given to the governor under Article 174, which was the draft Article 153. So it says that referring to the discussion in Constituent Assembly, the Supreme Court noted that framers of the Constitution expressly and consciously left out the vesting of powers to summon or dissolve the House solely with the governors. So this power must be exercised with the aid and advice of the Council of Ministers. So the Supreme Court discussed about draft Article 153, which became Article 174 in our present Constitution. Now this draft Article 153 provided discretionary power to the governor. However, during the discussion in the Constituent Assembly debates, this discretionary power was removed from draft Article 153 while the Article 174 was being drafted. So it says that draft Article 153 was substantially altered to indicate that the constitution framers did not want to give governors the discretionary power. And after looking into the debate, the Supreme Court in Bemang Felix case clearly stated and concluded that the only legitimate and rightful inference which can be drawn is that the framers of the constitution altered the original contemplation, that is, they altered draft Article 153 and consciously decided not to vest discretionary power with the governor in matters of summoning and dissolving the house or houses of state legislature. And this was done by omitting sub-article 3 of the draft Article 153 of the Constitution. So the Supreme Court decided that the governor can summon, prorogue and dissolve the house only on the aid and advice of the Council of Ministers, with the Chief Minister as the head and not at his own. So after understanding about these important judgments, let's understand about certain discretionary powers of the governor which can be inferenced while going through the provisions of the Constitution of India. Now the first is to reserve any bill for the consideration of the President under Article 201. Next is to appoint the Chief Minister of State under Article 164 Clause 1, including inviting the leader of single largest party in case of a hung verdict, so that they get a chance to prove majority on the floor of the House. Next, to dismiss the ministry also, as the Chief Minister and other ministers also hold office during the pleasure of the governor. Governor's report under Article 356 in case of failure of constitutional machinery in states, and governor's responsibility for certain regions such as tribal areas in Assam, and responsibilities placed to the governor under Article 371A with respect to Nagaland, 371C with respect to Manipur, and 371H with respect to Arunachal Pradesh. Now these are some of the special provisions provided in the Constitution of India. And regarding the use of discretionary power, Sarkaria Commission and Punchi Commission has suggested for the governor to act in a neutral manner and not in a politically biased manner. So Sarkaria Commission, National Commission to Review the Working of the Constitution, and Punchi Commission has reiterated the need for political neutrality of the office of governor. So neutrality of governor is best displayed when he uses his discretionary powers as per the constitutional provisions and he does not misuse them. So in this regard, the Sarkaria Commission has recommended the following criteria which must be considered while appointing the governors of state. He should be eminent in some walk of life. He should be a person from outside the state. He should be a detached figure and not too intimately connected with local politics of the state. He should be a person who has not taken too great a part in politics. And in selecting the governor as per the above criteria, persons belonging to minority groups should also be given a chance. Now further, the Sarkaria Commission also suggested that while choosing a chief minister in a state, the government should be guided by the following principles, especially if there is a hung assembly. So it says the party or a combination of parties that command the widest support in legislative assembly should be called to form the government. And the governor's task should be to see whether government is formed and not try to form the government which will pursue the policies which the governor approves. So basically, the Sarkaria Commission has asked the governor to stay away from the political activities of a government. Further, if no party has a majority, the government then has to invite a pre-poll alliance, the largest single party that is able to gain majority support, post-election coalition that has the required numbers, and a post-election coalition in which partners are willing to extend outside support. And in this regard, even the Punchi Commission has suggested to follow the same steps, but in a stepwise manner. That is, first a pre-poll alliance should be called, then the single largest party should be called to form the government, then a post-election coalition, and later a post-election coalition in which partners are willing to extend outside support. That is, a possibility of forming a minority government. Further, the commission suggested that whoever is appointed as a chief minister must seek a vote of confidence in the assembly on the floor of the house. Now, this aspect was also approved by the S.R. Bommai Supreme Court judgment. And this must be done within 30 days of taking over. And the governor should not resort to mechanism where determining of majority of the government is done outside the assembly. So the activity of deciding the vote of confidence must be done on the floor of the house in the assembly. Now let's look at these two prelims questions asked in the year 2019 and the year 2014. The question asked in 2019 was, which one of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links or should not have taken part in politics in recent past? Now in this, the correct answer becomes C, that is Sarkaria Commission. Other options were first ARC, Rajamannar Committee, Sarkaria Commission and National Commission to review the working of the Constitution. So here the correct answer is C. Now let's look at this question asked in 2014. It says, which of the following are the discretionary powers given to the governor of a state? Options were sending a report to the President of India for imposing President's rule. Yes, this is correct. Appointing the ministers. No, this is not correct. Reserving certain bills passed by the state legislature for consideration of the President of India. Yes. And making rules to conduct the business of the state government. No. So the question was select the correct answer using the code given below. So here the correct answer becomes B, that is 1 and 3 only. So we see questions have been asked with respect to discretionary power of the state and also with respect to political neutrality, which should be maintained by the office of governor as suggested by Sarkaria Commission. Both these articles becomes very important both from our prelims and mains perspective, and questions can also be asked regarding the discretionary power of the governor and also the role of the governor as envisaged in the Indian Constitution to ensure the federal balance between center and states. And from our examination perspective, this topic gets covered under GS paper 2, especially with respect to functions and responsibilities of the union and parliament and state legislatures, structure, functioning, conduct of business, powers and privileges, and issues arising out of these. So after understanding these two very important articles, let's take up the next article for discussion. Now let's take up the next article appearing on page number 7. It says control rather than privacy. The Joint Committee report on Personal Data Protection Bill has raised more questions than it has solved. So this article highlights certain concerns with respect to the present Personal Data Protection Bill, for which recently a joint parliamentary committee has also submitted its report. So in this regard, the author has highlighted certain concerns with respect to the Personal Data Protection Bill. Now this topic becomes important mainly from a mains perspective under GS paper 3, especially with respect to the aspect of security, and under GS paper 2 with respect to the aspect of governance and transparency. Now the concerns highlighted by the author in this article are fourfold. The first concern is regarding the processing of personal data without consent. Now this aspect has been provided under clause 12 of the Personal Data Protection Bill. The next concern is regarding exemption to certain agencies of the union government for processing of personal data. So the author has raised a concern that only the government agencies are exempted from processing of data, whereas the private entities are not exempted. So it has created two parallel universes. One, that of private agencies processing the personal data, and second is the government agencies processing such data of citizens. And in this regard, the provision provides immunity only to the government agencies. Now, the next concern by the author is regarding the Data Protection Authority. The first concern in this regard is that it is bound by the decisions of the central government. So, author has raised questions on independent functioning of this Data Protection Authority as envisaged under the Data Protection Bill. And the second aspect highlighted by the author is that there is also a need for State Data Protection Authority. Now, why this is so? Because ultimately the processing of data will take place through the states. So considering India's federal structure, the author has suggested that the flow of data will be from various states to the central government. So in this regard, apart from a central data protection authority, there should also be provided the provisions for State Data Protection Authority, as also the grounds of public order has been provided under state list. So based on all these considerations, the author has suggested that apart from Data Protection Authority at the central level, there should also be Data Protection Authority at the state level. Now lastly, the author has raised concerns with respect to inclusion of non-personal data within the Data Protection Bill. As according to the author, this will impact sharing of data across borders, because as of now, it is easier for MSMEs to share their data outside India because of cheaper rate of storing. So if data localization is mandated, that is, that MSMEs who are engaged in such activities and they have to store their data within the country, then such storing of data within the country for such MSMEs will make it costly for such companies to store their data. So these are some of the concerns which has been highlighted in this particular article by the author. Now to understand the concerns highlighted in this article, let us understand the key terms which has been used. The first is data principle. It means the natural person to whom such personal data relates. So in this regard, personal data means data about or relating to a natural person who is directly or indirectly identifiable, having any characteristic, trait, attribute or any feature of such natural person. Now the next term is data fiduciary. This means any person including the state agency, any company, any juristic entity or any individual who alone or in conjunction with others determines the purpose and means of processing of personal data. So they are such entities who determines the purpose and means to process the data. So in this regard, we should also know what is the meaning of processing. So processing of personal data means activities such as collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, use, alignment or combination, even indexing, disclosure by transmission, dissemination or otherwise making available, restriction, erasure or destruction of data. So all these aspects can be categorized as processing of data. And in this regard, data processor means any person including the state agency or any private company, any juristic entity or any individual who processes personal data on behalf of data fiduciary, that is on behalf of this entity. Now the Personal Data Protection Bill does not define non-personal data. It simply says that non-personal data are such data other than the personal data. So after having a clear understanding of these important terms, one by one, let's look into the various concerns which has been raised in this article by the author. So clause 12 of the Personal Data Protection Bill mentions about grounds for processing of personal data without consent given by such individuals. So it says that the personal data may be processed if such processing is necessary for the performance of any function of a state which is authorized by law, for the provision of any service or benefit to the data principal from the state, or issuance of any certification, license or permit for any activity or activity of the data principal by the state. So for both these purposes, personal data can be processed without taking the consent of the individual. Further, it can also be processed under any law which is made by Parliament or state legislature, for compliance with any order of the judgment of court or tribunal in India, to respond to any medical emergency involving threat to the life of a person, or in case of severe threat to the health of the data principal or any other individual. It can also be done to undertake measure to provide medical treatment or health services to any person during an epidemic, outbreak of diseases or any other threat to public health, or to undertake any measure to ensure safe or provide assistance or services to any individual during any disaster or any breakdown of public order. So for all these purposes, the government can process the data of an individual without taking their consent. And the concern raised in this regard is that this clause is an umbrella clause and does not specify which ministries or departments of the government of the Union of India will be covered under this particular provision. And another concern raised here is that the government can use these provisions as a means of control and surveillance. So it is because of this particular provision the author has titled this article as control rather than privacy, as this provision provides sufficient reasons for the government to process the personal data of an individual without their consent. Now moving to the second point of concern is regarding clause 35 of the Personal Data Protection Bill of 2019. Now, as I have already discussed, that this exempts agencies of the Union government from application of the law for processing of such personal data on grounds of public order, sovereignty, friendly relations with foreign states, and security of the state. But such exemption must be given in a written order. So the provision highlights that where the central government is satisfied that it is necessary or expedient in the interest of sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, or for preventing incitement to the commission of any cognizable offence relating to sovereignty and integrity of India, security of state, friendly relations with foreign states, or public order, then the central government may exempt any agency of the government with respect to processing of personal data, but such exemption must be recorded in writing. And this provision of exemption to be recorded in writing shall act as a procedure with respect to safeguard and override mechanism to be followed by such government agencies who are granted such exemption from processing of personal data of individuals. So the concerns raised here is that this bill creates two parallel universes, one for the private sector where the exemption will not apply, whereas for the public agencies or the government agencies for which exemption clauses have been provided for. Now the third concern raised by the author is regarding clause 86, whereby it mentions that the Data Protection Authority is bound by the directions of central government. So the independent functioning of DPA or Data Protection Authority has been questioned here. So this provision says that the central government may from time to time issue the authority such directions as it may think necessary in the interest of sovereignty and integrity of India, security of state, friendly relations with foreign states, or public order. So here the concerns raised by the author are, first, it says that the clause 86 makes DPA duty bound to follow orders of the government. This weakens its independence and gives the government excessive control over this authority. Another area of concern raised in this article is regarding the appointment of members of DPA by the executive, which according to the author goes against the earlier bill proposed by Justice B.N. Sri Krishna Committee, as this also provided a mechanism of judicial overlook. Further, the author has also mentioned that there must be an aspect of state data protection authority considering the principle of federalism, because with respect to flow of data from states to central government, states are key stakeholders in the process. And also the fact that public order has been provided under the state list. So here the author has said that if doctrine of pith and substance is applied on this particular legislation, then it will be clear that the flow of data from state to center, especially with respect to public order, must be monitored by an agency of the state government. So in this regard, the author has suggested to create a state data protection authority as well. Now, doctrine of pith and substance is applied when subject matter of a legislation falls in either of the central list or in the state list. So the idea is to find out whether the provisions of the law falls within which of the following list. And in this regard, pith refers to true nature or essence of something, and substance means essential aspects. So here the author says that if the doctrine of pith and substance of the legislation are related to the state, then it has to be monitored by the State Data Protection Authority. And here the author has mentioned about the fact that public order has been provided under state list. And according to the author, this becomes a part of state's domain. Now moving to the last concern, it mentions about non-personal data, whose explanation has been provided under clause 91 of the bill, which simply says that non-personal data means data other than personal data. So the author has suggested that by including non-personal data within the data protection bill, the Joint Parliamentary Committee has put a huge compliance burden on the economy, especially for such MSMEs for which data sharing and storing is a critical aspect of their business. So as of now in India, we do not have such an infrastructure on a scale which is there in the foreign countries. So in the present circumstances, storing of such data by say a small company outside India is comparatively cheaper. But if this aspect of data sharing across border is limited by the Personal Data Protection Bill, especially for the non-personal data, then this might impact the economic cost on these MSMEs. So it says that there is a probability that this provision might hit the MSME sector and small businesses harder, as technical processes involving data sharing are very expensive. Now the article also says that the government constituted panel headed by S. Gopalakrishnan regarding regulating of non-personal data also opposed this idea of inclusion of non-personal data within the data protection bill. And according to certain research, this mandatory data localization is estimated to squeeze the economy by 0.7 to 1.7%. So there is definitely an economic cost with respect to mandatory data localization or mandatory storing of data within the country. And this move may also invite similar measures by other foreign countries, which will hamper smooth cross-border flow of data. So again, these are some of the concerns with respect to inclusion of non-personal data within the data protection bill. Now, very recently, a joint parliamentary committee has submitted its report with respect to the data protection bill. So let's wait for the government to pass this particular bill so that it becomes an act. However, in this process, you should also know certain concerns which are raised now and then and appears in the articles of the Hindu newspaper. So in this regard, you should know these various concerns, especially with respect to data protection bill, and this topic gets covered under GS paper 3 and also GS paper 2. With this, let's take up the next news for discussion. Now the next article to be taken up appears on page number 6. It says a bill that could alter the mediation landscape. A spin-off from the mediation bill is that it has the potential to help relieve some of the pressure on law enforcement agencies, especially with respect to compoundable offences. Now, compoundable offences are such offences for which a compromise can be come to, or such offences under which there is a provision for compromise with respect to the accused and the opposite parties. So this article, written by a former Special Director General of Police of Chhattisgarh, has stated that this mediation bill, which generally provides for an alternate mode of dispute resolution, has another spin-off, as it can also help to improve law and order situation and also ease the burden of police, especially by encouraging compounding of offences, that is, settling of offences by the accused, as it will not only help in closing the cases, but it will also provide peace and tranquility in the society. Now, another benefit as highlighted in this article is that even matrimonial disputes are compoundable in nature and hence can be settled through mediation. So in this regard, let's go through some of the important features of mediation bill and also this aspect of improving law and order situation, as this will ease burden of police officers, especially with respect to investigation for that crime. Now this topic becomes important from the perspective of GS paper 2 under the aspect of governance and also special laws for the betterment of the vulnerable sections of the population. Now in mediation, the mediator acts as the facilitator and helps the parties to come to an agreement or close their dispute. However, with respect to arbitration, both parties select their arbitrator and there is also a third arbitrator, and this arbitrator finally decide the case and this decision is also binding. So the new mediation bill of 2021 aims to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial disputes or other disputes, and also enforce mediated settlement agreements. Further, the bill also aims to provide for a body for registration of mediators, that is the Mediator Council, and also to encourage community mediation and also to make online mediation as an acceptable and cost-effective process. So, the statement of object and reason highlights the significance of alternate dispute resolution. It says that there is a need to promote ADR mechanisms by institutional mediation, as mediation results in amicable resolution of disputes in civil, commercial, family, and even matrimonial matters, as it fosters collaborative approach, reduces the burden on the courts, and also help to preserve relationship among disputants. So the statement of object and reason highlights that bringing a comprehensive mediation law and providing for online mediation may serve the interest of all the stakeholders as effective alternative mechanism for dispute resolution. Now, some of the important highlights of the bill includes definition of mediation. Now, mediation says that it shall be a process and it can also be referred as either pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby party or parties request a third person referred to as mediator or mediation service provider to assist them in their attempt to reach an amicable settlement of a dispute. So basically the mediator acts as a facilitator. So according to the bill, mediator means a person who is appointed to be a mediator to undertake mediation and includes a person registered as a mediator with the Mediation Council. So you can go through these different kinds of mediation, such as institutional mediation means mediation conducted under the aegis of a mediation service provider. Now this mediation service provider must be registered with the Mediation Council. Now this mediation service provider means an organization which provides or conduct mediation under this act and rules and regulations and is also recognized by the Mediation Council. Now court annexed mediation refers to such mediation including pre-litigation mediation conducted at the mediation centers established by any court or any tribunal. Now, this bill also provides for international mediation, where at least one of the parties is an individual who is a national of or who habitually resides in another country, a body corporate, including a limited liability partnership having its place of business outside India, an association or body of individuals whose place of business is outside India, and any government of a foreign country. So, apart from online mediation, the bill also provides for international mediation. Now, regarding the enforcement as per the mediation bill, it highlights that a mediated settlement agreement resulting from mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and persons claiming under them respectively. So, this mediation agreement, if agreed by the party, shall be binding on them. And this mediated settlement agreement shall be enforced as per the provisions of Code of Civil Procedure 1908 in the same manner as it was a judgment of a court of law. Hence, the settlement agreement arrived through the process of mediation shall be binding. As already stated, that the bill provides for the Mediation Council of India to regulate the activities pertaining to mediation in India. Now, the bill also provides for certain matters which are not fit for mediation. However, a court may refer a dispute to mediation relating to compoundable offences, that is, such offences where compromise is possible, especially with respect to matrimonial offences or other offences. Now, it is here where the author highlights the benefits of such compoundable offences which can be included within the purview of mediation bill. So, section 7 of the bill says that courts will be competent to refer any dispute to mediation relating to the compoundable offences of matrimonial offences. Further, section 44 of the bill says that any dispute likely to affect peace, harmony and tranquility amongst the residents or families of an area or locality can also be settled through community mediation. Further, the provisions of Mediation Act or Mediation Bill shall not have an overriding effect with respect to Maintenance and Welfare of Parents and Senior Citizens Act, Sexual Harassment of Women at Workplace Act, as this act provides for an internal complaints committee as well. So, any offence under Women at Workplace Prevention, Prohibition and Redressal Act 2013 cannot be referred for mediation. So, the author suggests that providing some of the compoundable offences for mediation, including settlement of matrimonial disputes, will relieve some of the pressure on law enforcement agencies. Thus, this proposed law will not only help to prevent the breakdown of law and order through community mediation, but it will also help to relieve the police from the pressure of investigation in most of these compoundable offences. Thus, this article mainly becomes important from the perspective of governance and from the perspective of alternate dispute resolution mechanism. Now, this news appearing on page number 8 mentions about the fact that former RBI Governor Urjit Patel joins Beijing-based Asian Infrastructure Investment Bank, that is AIIB, and he will be vice president at the Beijing-based multilateral bank for a period of 3 years. Now, as you can see, a question was asked in the prelims of 2019. The question was with reference to Asian Infrastructure Investment Bank. Consider the following statements. AIIB has more than 80 member nations. India is the largest shareholder in AIIB, and AIIB does not have any members from outside Asia. So the question was, which of the statements given above are correct? So regarding AIIB, it is a China-led bank set up in 2016, or rather in 2015. Its member includes as of now 104, but does not include United States or Japan. Further, the membership is open to all the members of IBRD or Asian Development Bank. Total authorized capital is $100 billion. And regarding the voting weightage, it depends on share capital provided by different countries. Now, interesting to note here is the highest voting rights with respect to share capital. Highest is that of China and the second highest is that of India. And this is followed by Russia. So, India is one of the highest provider of funds for Asian Infrastructure Investment Bank. So, based on this understanding, the first statement becomes correct, whereas the second statement becomes incorrect as India is not the largest shareholder. And the third, AIIB does not have any members from outside Asia. This is also incorrect. So, the question was which of the statements given above are correct. So, here the correct answer becomes A, that is one only. Now, moving to the features of AIIB, it is a multilateral development institution based in Beijing, that is the capital of China, and its members spans across the globe. Further, this institution provides additional platform as an infrastructure financing institution to the already existing global financial institutions such as World Bank or IBRD. And it can also finance projects through making loans and investing in equity capital of an enterprise or institution. Now, AIIB follows a structured mechanism with China possessing the largest voting rights, including an effective veto power. Now, after China, it is India which possesses the largest voting rights in AIIB. Further, AIIB also allows co-financing of projects with other leading financial institutions such as Asian Development Bank, World Bank, European Bank for Reconstruction and Development. Now, another interesting aspect is that India is the largest recipient of funds from AIIB. So this makes AIIB unique in a way, as India is not only one of the largest contributor towards the multilateral institution, but India is also one of its largest recipients for various developmental projects. Now, in this regard, you should also know about the New Development Bank, as it was established through the BRICS Fortaleza Declaration. Its members includes BRICS countries. It is open to all UN members. However, voting rights of BRIC countries shall not reduce below 55%. It also has total authorized capital of $100 billion, and all 5 countries of the BRICS have been given equal voting weightage of 20% each. So a very simple question asked in 2015 prelims. The Fortaleza Declaration recently in the news is related to the affairs of. Options were ASEAN, BRICS, OECD and WTO. Obviously the correct answer here was BRICS. Thus this news should be seen mainly from the prelims perspective with respect to AIIB, that is Asia Infrastructure Investment Bank, which is based in Beijing. Now, based on our discussion, this becomes your practice question for the day. It says, consider the following statements. First, the governor shall summon each house of the legislature of the state. Second, the speaker of the state assembly can prorogue the house. And third, summoning of the house of state legislature is at the discretion of the governor. So the question is, which of the statements given above are correct? Option are A, 2 only, B, 1 and 3 only, C, 1 only, and D, none of the above. Now, coming to the answer of yesterday, the question was with reference to LCA Tejas. Consider the following statements. First, it's a completely indigenous aircraft. No, this is incorrect, as some of the components are not completely indigenous. Second, it has a maximum speed of 3 Mach. No, it has a maximum speed of 1.6 Mach. So the question was, which of the statements given above are correct? So the correct answer becomes D, that is neither 1 nor 2. With this, we come to an end to today's discussion. Thank you for watching DNS.